Hey everyone, welcome back to my channel. So some big news coming from the Novak Djokovic saga. His legal documents have been released. They are public now online. His lawyers claim in these documents something very interesting. They say that his infection, his COVID infection, was much sooner than we previously thought, which could give him some grounds to say why he hasn't been vaccinated. But the Australian government also has a letter dating back from November, which says you must be double vaccinated to enter the country. But ATAGI, the advisory group on immunizations, they're the ones who are listed in these legal documents, and they're also the ones who are listed on the government documents. It's going to be interesting to say the least on Monday in the court. But let's take a look at all these documents and go through, see what we can find. First off, on BBC News, I saw this here. It said breaking news. Djokovic, COVID infection gave him vaccine exemption, lawyers say. So the lawyers are claiming that his infection is giving him that exemption. When you look at the documents, potentially that's what he thought. He thought that he had the exemption cleared from Tennis Australia. Then the government comes out and says, no. But let's take a look. So we all thought Novak Djokovic was COVID positive back in June, which was previously reported, but this says something else. The date of the first positive COVID PCR test was recorded on the 16th of December, 2021. So that's what his lawyers said. So he had COVID only just in December, a few weeks ago. Djokovic was denied entry to Australia after landing in Melbourne this week to play in the Australian Open. He's currently in immigration detention with a court challenge due on Monday. The case involving the world's top-ranked tennis player has caused a huge outcry in Australia and made waves around the world. Yep. Djokovic, who has said he is opposed to vaccination, had been granted a medical exemption to play in the tournament in a decision that infuriated many ordinary Australians. So when he got to Australia, the Border Force officials said he had failed to provide appropriate evidence. However, look at these court documents released on Saturday, which is now. Djokovic's lawyers said that 14 days after testing positive in December, the player had not had a fever or respiratory symptoms of COVID-19 in the last 72 hours. So asymptomatic after he's already recovered. Now, let's take a look at these court documents. It's come from the Federal Circuit and Family Court of Australia, and it's the Novak Djokovic versus Minister for Home Affairs. That's the same minister we spoke about before, the Home Affairs Minister, who said, well, we're investigating other players now, who I just did my last video on, another player who they found out the same visa that she was given as Novak Djokovic, well, she's now going to be deported because she doesn't want to contest it. But let's take a look at what it says. So it's an application from the Migration Act. Then they got the court date. They got all the details. So grounds of application. On or about 5th of January 2022, the applicant arrived at Melbourne Tullamarine Airport, which we saw a photo of before in my previous video. At that time, the applicant held a subclass temporary activity visa. At or about 4:11 a.m. on 6th of January 2022, an officer of the Australian Border Force gave to the applicant a notice of intention to consider cancellation under Section 116 of the Migration Act. The Border Force gave him one that said, this is to consider the cancellation of your visa because you haven't provided the proper paperwork. This goes through with the interview, what happened during the interview. So he said, you stated you're not vaccinated. You've also provided a copy of your medical exemption issued by Tennis Australia. This exemption was issued on the grounds that you have recently recovered from COVID-19 under the Biosecurity Act 2015, that there are requirements for entry into Australia. These requirements include that international travellers make a declaration as to their vaccination status. Travellers may make a declaration that they have a medical contraindication. Previous infection with COVID is not considered a medical contraindication. Now here's the ATAGI part. On or about November 26, 2021, the Australian Technical Advisory Group on Immunisation promulgated a document entitled ATAGI Expanded Guidance on Acute Major Medical Conditions that Warrant a Temporary Medical Exemption Relevant for COVID. The guidance addressed when temporary exemptions from vaccination for COVID may be granted on the basis of acute major medical conditions. And this says, ATAGI exemption guidance provided relevantly that valid reasons for a temporary exemption include for all COVID-19 vaccines, for all, PCR confirmed SARS-CoV-2 infection where vaccination can be deferred until 6 months after infection. That's it right there. Because they're claiming he just had COVID and recovered from it. So he had it on the 16th and he's already recovered. And this says that ATAGI, the Technical Advisory Group, says valid reasons for an exemption for all vaccines is a PCR confirmed infection. So a positive test where vaccination can be deferred until 6 months after the infection. Because what we heard before is if you've had COVID, it's not advised that you get the vaccine within 6 months. Now, in particular, the ATAGI vaccination advice provided in relation to recent infection, which is what we're talking about. COVID-19 vaccination in people who have had PCR-confirmed infections can be deferred for a maximum of 6 months after the acute illness as a temporary exemption due to acute major medical illness. Because having COVID and then getting the jab within that 6 months could cause acute major medical illness. That's what it's saying. That could be an exemption for it. So him having COVID in December gives him a bigger chance of being able to maybe fight this, because they say right here in these documents that the same group or advisory committee that said people who contracted COVID-19 within the past 6 months and seek to enter Australia from overseas and have not received 2 doses of a TGA approved vaccine are not considered fully vaccinated. And it's saying that who do not meet the ATAGI's definition of fully vaccinated will not be approved for quarantine-free entry. Well, that's what the Prime Minister and the government is saying is the reason why he's not allowed in. However, that same advisory group says COVID-19 vaccination in people who have had a positive test can be deferred, so put off for 6 months after the acute illness, which he just had on December 16th, as a temporary exemption. So right there, it says he could get a temporary exemption because he's just had COVID. And that's, I believe, what he thought was happening, because he got the letters from Tennis Australia, which said, yep, you've previously had it, so you don't need to get it for 6 months, so you can come in due to a medical exemption, because it says right here that ATAGI says it could amount to major medical illness. It's right there in the court documents. This could be it. This could be the reason why he might win this court case. So the applicant provided evidence to the delegate that he had COVID infection within the previous 6 months, indeed within the last month. Accordingly, the applicant met the criteria for a temporary exemption under the ATAGI exemption guidance and fell within the ATAGI vaccination advice in relation to recent infection. Hereafter, the ATAGI exemption guidance and the ATAGI vaccination advice, the principles, the decision was made purportedly in application of the ATAGI principles. So they put a web page, the Minister for Home Affairs, that's who they're going up against. So they put a web page that links to a homeaffairs.gov website, which says it implies a relation to unvaccinated persons arriving in Australia that having a medical contraindication recorded in the Australian Immunisation Register constitutes proof that you cannot be vaccinated for medical reasons when coming to Australia. This is going to be interesting on Monday. That's what I can tell you. The Australian Immunisation Register medical exemption, which is relevant to exemption from vaccination due to medical contraindication, states on page 3, the Australian Technical Advisory Group on Immunisation, ATAGI, has released expanded guidance on acute major medical conditions that warrant a temporary medical contraindication relevant to COVID vaccines. So this is what they're saying, the delegate, their reasoning for why they cancelled the visa. The visa holder stated that Tennis Australia facilitated his medical exemption from COVID vaccination requirement and completed the Australian travel declaration on his behalf. I consider that Tennis Australia would have facilitated his medical exemption and Australian travel declaration based on information the visa holder provided to them. That's what I said. I think he's got his information from Tennis Australia and he thought he was all good and gets to the border force and they're like, nah, I don't think so. Based on the above, I apply significant weight in favor of visa cancellation for this favor. The absence of extenuating circumstances could not logically or rationally constitute a factor in favor of cancellation. It could only logically, rationally constitute a neutral or irrelevant factor. So right here, his lawyers are claiming there was a denial of procedural fairness towards Djokovic. They're claiming he was given the notice at 4:11 in the morning. The applicant was invited to provide comments at an interview at 4:35 in the morning. At 6:07 in the morning, he asked for further time in which to provide comments, having received advice from his lawyers. And then a border force officer said the applicant could have until 8:30 to provide comments. So he's been told he's got until 8:30 in the morning, but at 7:30, an ABF officer, don't know if it's the same one, said to the applicant, words to the effect that the applicant's lawyers would not be able to do anything to help him until a decision was made either way. So it would be best if he answered their questions about his medical condition then and there. So they're trying to strong arm him into answering. After further exchanges, the officer left the room. As outlined, the decision was purportedly made at about 7:42 a.m. The process outlined above, which we just read, involved practical injustice to the applicant. Had the process represented to him involving his making further comments at 8:30 been followed, he would have had an opportunity of making representations regarding the content of the ATAGI principles, which we looked at before, which said that vaccination could be deferred if you've already had COVID. Now, this one is about submissions, and it's about 35 pages worth of documents. So they're saying what we just spoke about before when the border force officer was telling him that he could have the time to check the principles, which he didn't know about. But then a border force officer came at 7:35 or something like that. It says it was legally unreasonable in the sense contemplated in a legal case. So they're bringing up case law as well. Arrived just before midnight on the 5th of January with a view to competing at the Tennis Open, commencing on the 17th. Now they're saying it talked about what kind of visa he had. It was subject to no condition having the effect that his right to enter and remain in Australia was qualified in any way in regard to his vaccination status. That right there is saying that there was no conditions on his visa and there was no regard for anything about his vaccination status that would have any effect on his visa. The lawyers in these papers are saying. Mr. Djokovic had received on December 30th a letter from the Chief Medical Officer of Tennis Australia, exemption certificate, recording that he had been provided with a medical exemption from COVID vaccination on the ground that he had recently recovered from COVID. The exemption certificate also recorded the date of the first positive COVID PCR test was recorded on December 16th, and it's now been 14 days when this was posted, and Mr. Djokovic has not had a fever or respiratory symptoms of COVID in the last 72 hours. The exemption certificate had been provided by an independent expert medical review panel commissioned by Tennis Australia. So he's got a contraindication, which Atagi recognizes because he was COVID positive in December, and they give him the 6 months delay period. And then it says that he had an exemption certificate, which was provided by an independent expert review panel commissioned by Tennis Australia. The decision of that panel had been reviewed and endorsed by an independent medical exemptions review panel of the Victorian state government. So when the Victorian health minister came out and said that it wasn't Victoria that issued him a visa, well, the Victorian government, according to these legal documents, had a medical exemptions review panel which reviewed that decision, that previous decision by Tennis Australia. The conditions of the exemption are consistent with the recommendations of the Australian Technical Advisory Group on Immunisation, ATAGI, and they're the same ones that the Prime Minister quoted as saying, if you don't have your vaccinations, you can't come in. If you're not double vaccinated with an approved vaccine, you can't come in. However, he had two panels approve his exemption. So Novak has done absolutely nothing wrong, in my opinion, based on these facts and these documents. He thought he was given a legitimate exemption by Tennis Australia with his documents. Someone said took the photo of him at Tullamarine Airport. He had a bunch of documents from Tennis Australia with him. So this right here, I'm really pissed off with this because the Victorian Health Minister said that they didn't approve his visa because the federal government approves visas. But it says right here in court documents that their medical exemption review panel of the state government of Victoria reviewed and endorsed it. And the federal government now has an issue because that letter from November is earlier than what these papers are here, because he was given this after that letter on November. So this supersedes that letter potentially, because even though it's still Atagi who said that you need your double vaccinations, well, it's also Atagi who is saying, yeah, you're good to go with the medical exemption because you've just had COVID. Oh, this is gonna get either really interesting on Monday or really ugly on Monday in court. He had also received on the 1st of January, so New Year's Day, a document from the Department of Home Affairs, who they are going up against in this court proceedings. In regard to his Australian travel declaration, the declaration assessment told Mr. Djokovic that his Australia travel declaration had been assessed and that his responses indicated he met requirements for a quarantine-free arrival into Australia were permitted by the jurisdiction on your arrival, the jurisdiction being Victoria. The Home Affairs Department gave him a document on the 1st of January which said he met requirements for a quarantine-free arrival. So if the Home Affairs Minister wants to come out and say, we're trying to find other players who had this visa who shouldn't be here, why would you give him a document that says he can be here and have quarantine-free arrival? So these 3 points right here are the reasons why he should be allowed into Australia. Because he held a visa unqualified by any relevant condition. He received certification of a medical exemption from vaccination from the tournament organizer, who we saw above, and the certification being granted after a review by a panel established by the Victorian state government because he's playing in Victoria. And we just saw those two right there. There you go. Panel by Tennis Australia and a review panel by Victorian state government. The final bullet point, that he had received from the Department of Home Affairs a document informing him he met the requirements. He received that document from the Home Affairs Minister. So these 3 points, according to the legal documents, were all met. These 3 requirements were all met for him to come into the country and have quarantine-free arrival and be able to play in the Australian Open without having to take the vaccine. Mr. Djokovic understood that he was entitled to enter Australia and Victoria and to compete at the Australian Open tennis. However, Mr. Djokovic's visa was purportedly cancelled by a delegate of the respondent. Delegate at Melbourne Airport, purportedly relying on Section 116 of the Migration Act, Court of Decision Act. This occurred after he was in immigration clearance for the most part incommunicado for about 8 hours. Yeah, so they took him where they could just question him, where it said before we looked at, the border force were just going to question him on their own, and they were like, well, you just got to make a decision. Don't worry about your lawyers. And then they've listed again the timing of what everything happened. So at 7:42, he was notified of that decision. Thereafter, Mr. Djokovic was taken to Park Hotel, where he has been detained ever since, notwithstanding his request to be moved to a more suitable place of detention that would enable him to train and condition for the Australian Tennis Open, should this present challenge to the purported decision be successful. Mr. Djokovic submits that the purported decision was affected by a variety of jurisdictional errors as set out in his proposed amended originating application dated 7th of January. He seeks that this court quash the purported decision and associated relief as set out in the AOA. If the minister is considering cancelling a visa, whether its holder is in or outside of Australia, under Section 116, which they claimed, the minister must notify the holder that there appear to be grounds for cancelling it and give particulars of those grounds and of the information because of which the grounds appear to exist, and invite the holder to show within a specified time that those grounds do not exist. There is a reason why it should not be cancelled. Well, he gave them all the papers that he had from Tennis Australia, which would have also had another panel review, which would have said, yeah, ticked it off from the Victorian state government, which was complying with ATAGI measures. And he also would have had the paper from January 1st from the Home Affairs Minister, who it says right here, the Home Affairs Minister, if it's considering cancelling the visa, must do these things. But they didn't, because when he got to the border force down in Tullamarine in Melbourne Airport, they said it doesn't exist. This doesn't count. So they just took him to a back room where they questioned him for hours and then just took him to the detention hotel, where he's been for the whole time. There's this reference to this delegate again. He's got all the papers with him. He's got all the paperwork that proves that he has the exemption from Tennis Australia and a medical board from Victorian government and the Home Affairs Minister's paper that says he can come in. So he's got the federal government approval, he's got the state government approval, and he's got Tennis Australia's approval. All three of those. And then you've got this delegate talking to him when he gets to Melbourne Airport. Who is this delegate? I don't know. The delegate's use of the passive voice in the phrase is not considered. Considered by whom? Strongly suggests that the delegate is relying on information or guidance derived from another source or a policy. That inference is further strengthened by the statement put out by the respondent on the 5th of January while Mr. Djokovic was in the air on his way to Australia. That statement refers on several occasions to Australia's strict border requirements and says the unvaccinated persons are able to access the same travel arrangements as fully vaccinated travellers only if they provide acceptable proof that they cannot be vaccinated for medical reasons, which is what we've said before, that they gave him that exemption. So that's the issue there. It seems like someone was working off other information or sourcing some other legal definition that they wanted to bring up themselves or they had been told to bring up by someone else. But everything that he was given when he arrived in Australia, it seems like all the papers that he was given was approval from the federal government with the Home Affairs Minister's paper, approval from the state government when they approved Tennis Australia's medical board decision and they had their own medical board approve it, and then Tennis Australia's letter that said, yeah, you're all good to come in. You've got the exemption. And we've referred it to the ATAGI advice. So it's going to be very interesting on Monday when this court case actually happens, and I will be very interested to see if he wins this case, because on all the evidence I've seen, it seems likely now, more likely than I thought, that he actually could potentially win this case and stay in Australia and play in the Australian Open. This has been a bombshell, and I'd like to know your thoughts on it. Let me know your thoughts down in the comments below. Don't forget to smash the like button. Please subscribe to the channel if you haven't already. Share this video out there, and I'll see you in the next one.